Ivan is a member of the Allers and Cooney Public Finance Law and Litigation Group. He focuses on serving cities, city utilities, school districts, special districts, and other local governments in the exercise of their powers and in litigation. He's got over 41 years of experience in local government and litigation. His representation in litigation includes both federal and state courts, as well as practice before administrative agencies in regard to such matters as eminent domain, taxation, annexation, and utility matters. He has represented cities in all aspects of their operations, defending cases involving open records and meetings, establishing municipal telephone services, special assessments, franchises, and exercise of home rule powers. I don't want to exclude public service. It's important for attorneys to be involved in the community, and a few of Ivan's services in the past in the community area is with Iowa Legal Aid, with Polk County Legal Aid, and with Central Iowa United Way. Welcome, Ivan.
Thank you, Mark. Good afternoon to everyone who's in attendance. Let me get right started with this, since I figure out where my watch went. So I can actually time myself. Let me start right off with the definition of what is a municipal utility. What I have given you in the first slide is the definition. Now, there are two parts of that definition that have some interest for us. The first part is simply the list of what are municipal utilities, and you can just look at the list. I want to point out something that will become important later on in the talk for a minute, and that's what normally looks like the tagline in. And that is where they describe what is part of the municipal utility. All lands, easements, right-of-way fixtures, equipment, accessories, improvements, appurtenances, love that word, and other property necessary or useful for the operation of the utility. Stay tuned and pay attention to that. We will come back. Next is, how does one form a municipal utility? There are actually two ways to form municipal utility, and now we start separating out things. Put sewer systems, both stormwater and sanitary, sort of to one side. All other city utilities, everything on that first list from Chapter 362, has to be formed by an election. Now, you also get rid of utilities by election, either to sell them or to transfer them or to merge them, with one exception, and that's at the end of the section, that those which haven't been operating for 5 or more years can simply be abolished by city councils. I've yet to see that happen, but that's in the code. Once you establish a municipal utility, it is not self-executing that you have a municipal utility. You should pass ordinances implementing the utility, establishing the limits on home rule. There's an argument as to whether the powers granted to a municipal utility limit municipal home rule or extend municipal home rule. 99.2% of the time that doesn't matter. Sometimes it does matter, and I will mention some of those later on. The utilities can be thought of in groups, and I haven't put this in the slide, but let me make you think about it this way. Think about electric, gas, and water utilities as one group. One way to think about them is that those are also the utilities that can be franchised if they're privately owned. The franchises become very important because when we look at what the city can do when you have a separation between a utility board and a city council, what can the city do and what can the city and the utility board do? One way is to remember that in effect there is a franchise for a municipal gas, electric, or water utility. That's one set of utilities. I also want you to think about another set of utilities, and those are the communications utilities. Now, we think of a communication utility, and communication utilities are established as a single item. They are really three separate types of utilities, maybe four, and they run this way. You have the cable, that is traditional cable television utility. That utility has a parallel in the private sector. Think of Mediacom. That utility is subject to a franchise, and we'll get into some special statutes. A good deal of what we consider to be franchisable authority and what cities can do with franchise cable utilities also turns out to carry into publicly owned cable television. Then we have the internet, which isn't franchised, which isn't regulated much by the state. It has had some federal regulation. Then you have telephone, which isn't franchised by the state. Cities can't franchise telephone, but which has authority granted to cities under the Iowa Utilities Board, but with, again, some special statutes. And then you have wireless, and you may wonder, if you go back and look at the definition, where in the world did I get wireless? And you really need to go to the end of Chapter 388, look at the footnote at 388.9 and 388.10, and you'll see a reference to 99 Acts, Chapter 63, Section 1, and that's where you find legislative intent. And legislative intent is basically that you can provide any of those other services by wireless provision. Then there are the sewers, third layer. Sewers, oddly enough, can be franchised utilities, can be non-city utilities, can be private, can be water districts. They are outside of Chapter 364, and for all of those that are non-municipal, I intend to say absolutely nothing. I'm also not covering special districts. I'm not going to cover special financing by utilities, but you should be aware of Chapter 28F in regard to electric utilities, to special districts, and to Chapter 28E. Now, sometimes we find people trying to avoid establishing a municipal utility by going to the administrative portion of the code, 392. Just point out the last portion of 392.1, the last language, last sentence in that section says that you can't create an administrative agency to function as a municipal utility. So you are going to have to make a municipal utility the way municipal utilities are supposed to function, and that is under Chapter 388, Chapter 362, Chapter 364, and some others. Two ways a utility can be governed, and this distinction has some importance down the line. Can either be run by the City Council, and the City Council would then basically run the utility as a department of the city, and would appoint the manager and handle it like the engineering department, the parks department, any other department. The second way is that it can be run by a utilities board. Now, a utilities board has to be established by the election of the people. When a municipal utility is established, there are two separate questions, or can be two separate questions. One, shall we establish a utility? Two, shall that utility be governed by a utility board? And that has to specify whether the utility board shall have 3 members or 5 members. Now, the utility board can run more than one city utility. So it's very common for cities to have a water utility, to have a gas utility, to have an electric utility, and to have a communications utility. It's not common for them to have all 4. To have 2 or 3 of them is fairly common, though. Electric and water, of course, the most common. And the same board can govern them both. Or you can have the situation where one of those utilities is run by the City Council and another run by the board. One question that comes up, though, is can they all be run together? The answer is yes, they can, but you've got to go through a special procedure to make them run together. And that procedure is seldom used. So we usually have very separate utilities run by one board. Now, I've got the slide up now going back to the board question on the 3 to 5. And one of the questions that's become rather warm in Iowa at the moment is, how do you change the size of the board? There is an Attorney General's opinion that says that the City Council can change the size of the board. I think there's some bond attorneys on the call, and they may have a different view. The cautious view is that you need to do it by election, because the board is established by election, the size of the board is established by election, and you may not want to rely, if you want to change the size of the board, entirely upon that Attorney General's opinion. Likewise, can you remove a board member? And the answer to that question is yes. At least most of us think yes. There's not an appellate court decision. There's a recent Iowa District Court decision out of Oskaloosa that says that the appointing authority can remove a board member. That's the mayor and council. You follow 372.15, which is the ordinary provision of the Iowa Code for the elimination or for basically getting rid of people in municipal employment or municipal appointees. The big question is with or without cause. The district court said without cause, because there's no cause in 388, there's no cause in 372.15. My general view would be to be cautious. You're always much better off with cause. There is some argument that because they're members of the utility board are appointed to an actual staggered 6-year term, that term vests them with some interest in office, and that vesting in interest of office is such that it requires that you cannot get rid of people without having some cause to do it. To say both of these issues, how to change sides and whether you need cause to get rid of a utility board member, are still open. Here is something that does get to the distinction between a board and a city council. If you look at the 364.2, the first sentence there, it says a power of a city is vested in the city. Power of a city is vested in a city council except as otherwise provided by law. Well, the next section, 388.4, vests power of the city in another board. The second sentence, a utility board may exercise all powers of a city in relation to the city utility. Yeah, okay, so what are the powers that the city council has retained, and what are the powers that the utility board has in relationship to one another? As far as the power of the authority of the city, remember the language I pointed out on the very first slide, that sentence in 362.2, which says that the utility includes all land, easements, right-of-way, fixtures, equipment, accessories, improvements, appurtenances, and other property necessary or useful for the operation of the utility. So the utility would certainly have authority over all of the property actually used in delivery of utility services. That said, I'm not sure I can tell you exactly what that means. I want you also to note one thing before we leave this, that is that the utility board independently has a right to condemn property, that's down in section 2, and also that all the property held by a utility, municipal utility, whether it is city run by the city council or city run by the city utility board, must be held in the name of the city. Now, you will notice something I just said, city run, city run. I said it twice. A municipal utility, whether it is run by a city council or run by a utility board, is the city. It's simply the city wearing a different hat. So if you have a city where the city council runs the waterworks, that's easily seen. If you have a city like Des Moines, which has a separate water board, that water board is still the city of Des Moines. It's still the water governing body of a city asset that belongs to the people of the city and is treated that way. Now let me get directly to the questions of, are there inherent disputes in the operation of a utility board and a city council? And the answer to that question comes quickly to this. Think about the right-of-way. And if you look out to the window, hopefully you all have a window someplace, you'll see a street. And on the side of that street, there's still municipal right-of-way. And there is, in that municipal right-of-way, along with that street, and along with the sewer run by the city council, there may be a water line, there may be a gas line, there may be an electric line, there may be cable, all of which belong to the city through the utility board, which is supposed to have control over that property. So if the city passes a right-of-way control ordinance, which generally tells people where they have to be in the right-of-way, controls when you have to go underground, who goes underground, when they go underground, does the utility have to obey that? And the answer, of course, is a strong maybe, because we don't have enough facts from what I just said. Some of those movements, and I want you to go back, remember I talked about the parallel between city authority over municipal utilities, in this case municipal utilities that are board run, and the ability of the city to control franchised utilities. One of the things that overrides the city's ability to control its own right-of-way are some IUB rules about safety. We'll mention those in a while again, but whenever you're talking about especially gas and electric, things that have some strong safety proponents to them, there are IUB rules and IUB authority concerning safety, which the city must obey, whether it's a council run or board run, and the IUB rules trump whatever the city wants to do. There's another issue that comes up, tree trimming, which is sometimes when you have an electric utility or a cable utility, one of the most exciting parts of working with the public, because you want to see people really upset, have some bad tree trimming. You would think we just stole their firstborn children. So if the city attempts to have a tree trimming ordinance to control the utility board, does that tree trimming ordinance control? I think it does. The reason is because the tree trimming is actually within the city's authority to control the right-of-way. It's not, the trees are not the property. Remember, that's what we listed in 362 is all the property of the utility. It's not the property of the utility. And it is very common for us to require tree trimming to national standards with municipally franchised utilities, with electric franchise utilities, Mid-American, Interstate Power, Alliant. Common for the franchises to say you're going to have to follow ANSI standards for cutting trees. I think we can do that with the city's own utilities. I would think they would want to volunteer to do it, by the way, but that's secondary. What about undergrounding ordinances? It's become rather common lately for cities to want to have utilities go underground. Can the city require a utility that's municipally owned to go underground? I don't think you can do it directly. You can probably do it indirectly because you have the power to appoint the board and unappoint the board. But undergrounding is generally handled by the tariffs for private utilities. And since it's handled by the tariffs for private utilities, that would appear to be not something that the city would have authority over. That appears to be something that the utility has authority over. And in this case, the utility would be represented by the city utility board. And I've sort of run over that analogy. Let me tell you why I think that analogy makes some sense between a franchise utility and a city utility. A franchise has two aspects when we grant it to a private party to provide utility service. Aspect one is the right to do business, to conduct a certain business, and the conducting of the business is the second aspect, the right to use public property to do so. A municipal utility, by virtue of the election which creates it, has the right to do business and has the right to use public property, public right-of-way, which makes it very parallel to the private utility. So when thinking about what the city council can do, it is helpful, not necessarily determinative, but helpful to think, is this something a city could do to regulate one of its private franchised utilities? If it is, then it's probably something the city council can do to regulate a municipally owned utility. So let's go on to some of the specific powers granted to municipal utilities. And these are some notes on eminent domain because they run a little different than one would think when we deal with certain rights of the city. This is actually from you should get this. This is 363.1. I notice I don't have the section number on here. Has to do with the right of a city to acquire property outside of the city. And you will note that there's in section 1A, there is an exception that the power does not include the power to acquire property by eminent domain outside of the city. And then there's an exception. And one of the exceptions is that the operation of municipal utility can be such that you can use, that the municipal utility can use eminent domain powers outside of the city. The question may be, why would the city want to use eminent domain powers outside of the city for utility purposes? Note the word operation. If you go back to 362.2 again, you will not see operation defined, despite the fact that's what the section says. There are two major reasons that you would use eminent domain powers outside of the city. One is for transmission of electricity, transmission of gas, transmission of water. Your sources of gas, electricity, and water may be in the city, rarely are in the city, usually are someplace outside of the city. So to bring the utility service into the city, you need to be able to use eminent domain powers. Same thing with sewage treatment plants generally located outside the city. To connect the sewer to the sewage treatment plant, you may need to use eminent domain powers, again, outside of the city. Well fields, those things which are the source of water itself, are commonly outside of the city. Which brings us to, okay, you're outside the city. Now what? Well, one of the now whats is that there is a definition of public purpose that limits the ability of governments, not just cities, governments, to take agricultural land. And I point out 6A21.2, the last sentence to you, that limitation does not apply to municipal utilities. You may need to, it's the last sentence, you may need to read it a couple of times, but you'll see that we are another utility with the right by statute, we gave you the statute before, to condemn land for the public power. So for any of those things I listed, transmission, well fields, sewage treatment plants, connections to sewage treatment plants, you can use eminent domain powers of the city. Unless, I love unlesses. You happen to be mostly in southern Iowa. This is also from 6A. And there are a set of limitations that apply to surface water sources, sometimes called reservoirs. The first thing you should note is on this page, under C1, second line down, starting with only that number of acres justified as necessary for a surface drinking water source not otherwise acquired may be condemned. So if you can only condemn the minimum that you need. You can't condemn for recreational purposes. There are, as you'll notice, going down the list, some ancillary and auxiliary purposes for which you can condemn, including the surrounding area that's needed for necessary setbacks. And you have to get an engineer's certification. That's that last paragraph on this page. Also, the extra land is the paragraph on this page. Before you can determine how much land you can actually take. If trees are bad, if tree trimming, by the way, is a battle, this is like the 100 Years' War when you need to build a reservoir. Okay. One of the most important things a city does is set the rates for utilities. This is 384.84. It is the governing statute. Let me point out a few things about this. If you go down under 384.84.1, there on the page, to start with the line that says gross revenues, this is what you can do. Gross revenues at least sufficient to pay the expenses of operation and maintenance of the city utility. It is a cost recovery system. You are not supposed to operate at a loss. The whole idea is that you take your expenses, and your rates need to cover at least the expenses, which means you need to plan to cover a little more than expenses, which the Iowa Supreme Court has said you can do. Note a couple of procedural matters, the last sentence of the section. Rates must be established by ordinance of the council or by resolution of the trustees published in the same manner as an ordinance, which means you have to go through 382 if it's a city council, requires 3 readings like any other ordinance, and either the ordinance itself or a summary be published. If you're a utility board, you only have to pass a resolution which requires one vote, but it also requires either the summary or the entire ordinance to be published. For some purposes, you may need to notify IUB. That becomes more of a footnote these days than anything else. We'll get back to this in a second, but I want to mention a couple of things on this page. If you notice at the bottom, I've given you, this is also in 384, 7A1, which allows for connection fees. So there are two different sorts of connection fee thoughts that you can have. One is under the special assessment statutes, which is earlier in 384, or this is a cost recovery for simply the connection when you're not building a new system and using connection fees to pay for that system. Under the special assessment, you use the connection fee to pay for the system. Here, the connection fee, although it's using the same language, is to pay for the cost of actually making the physical connections and extensions necessary for individual systems, even after the system is built and even paid for otherwise. Very important down here is number 2. Normally you can do classes, and most classic, just think of the water rates or the gas rates or the electric rates. You'll have a residential rate, a commercial rate, an industrial rate. Those classes, as they have a rational basis, are fine. What if you have somebody who doesn't fit any of your basis? And that's where we address at 7A2. This is again 384-84. The city can, by contract, the utility by contract, can provide a special rate to those whose type or quantity of use of service is unusual. The only case we have on this indicates that unusual does just simply mean it's out of the line, and that case involved special water rates and special sewer rates for a big user of water, like 30% of the capacity of the water. It's legal under Iowa law to, by contract, provide a special rate. Now, to 364-4, and this is one of those statutes that starts looking really simple, but has lots of history and isn't as simple as it looks. By contract, this is what a city may do. By contract, which would include a city utility run by a board, extend service to persons outside the city. This means a written document, as some way to show. And by the way, a municipal utility should have a service agreement, a contract, with everybody to whom it provides service. The contract with people outside the city can be the same contract, but it doesn't need to be. And there's a good reason for it being a different contract, because you can charge a different rate for people outside the city and inside the city. But there are a couple of glosses on this statute that do not appear in the face of the statute. First of all, any extension outside of the city must be for public purposes, that it must benefit the city system somehow. And just making more money is not considered a benefit. If it enhances the system, if it's a way to loop an electric system, way to loop reliability of the system, and you're outside of the city, just dropping off service is fine. If it is people who are who you run your mains by as you run into the city, and they want city water, that's fine. By the way, raw water, back in the statute we were just looking at, raw water is a special type of service. You could charge differently for raw water, people who take service off the water before they get to the city. There's a second gloss that on the public purpose and the outside of the service territory, and that is the city may only provide municipal utility services outside of its boundaries from surplus. There's a long set of articles in McQuillan about this. There is a single Iowa case in which that statement is dicta. The case isn't in the materials, but I'm about to give it to you. It's Carroll, C-A-R-R-O-L-L versus City of Cedar Falls, 261 Northwest 652, 261 Northwest 652, Iowa 1935. For those of us who practice in municipal law, we call a case decided in 1935 a recent decision. The The problem with this is that it's very difficult to define what a surplus is. Generally, if you have a municipal utility and it has a well that is capable of producing 10 million gallons a day and it's only producing 5, you have some surplus capacity. You can provide service outside the city to that service capacity. Whether you can serve 5 million gallons of water outside the city, because you probably then endangered the city's ability to serve itself, is an open question. I would say that I would not recommend it. There are 2 exceptions where the city is required under Iowa law to provide service outside the city. The surplus and public benefits simply don't count. Electric utilities, municipally owned electric utilities, which are subject, and they all are, to the Iowa Territories Act and have territory outside the city, must provide electrical service to the territory outside the city. And telephone utilities, communications utilities that provide telephone service, must provide service within the exchange area for which they have a certificate. In regard to the city's telephone service, that service doesn't have to be provided over a city facility. In fact, the cities that have been caught in this buy the right to use existing lines to provide city service outside the city. That is really a bad idea because that usually costs the city more than it's going to get. On the question of rates, how to set them, there are also some questions as to how the rates can be distributed. And here we go with a couple of statutes that are important on that point. City may not discriminate as to rates, but it can provide itself and its agencies, the library, free use. You can, if you have the capacity to do so, make reasonable classes. And classic classes exist. And it's what we've already talked about: residential, industrial, commercial. Those all are okay as long as you treat everybody within the class the same. And of course, people who don't live in the city, with the exception of electric and telephone, because there are slightly different rules, you can give them different rates. Note the exception for free service to the city, which is down below, which is you've got to make sure that any free service complies with what you've told the people who own city debt you're going to do with the rates. And if you don't accept out the city rates in your debt, then you're not going to be able to accept out the city rates from the city paying the cost of the service. We see often people want to give free service to schools, to churches, free service for economic development. None of that's allowed by the statute. They all pay, and they all pay under whatever class you have. There is an exception, and I'll repeat this later where it comes up under the statute. It's an exception for promotional rates for competitive communications utilities, and there's a special statute that allows that. Now, there are a couple of other unusual things that happen. And let's hit this one. Again, I've seemed to miss the section. This is 364.3. Both this page and the next page are 364.3. This has to do with cable. Think Mediacom, other major providers. If you have in a city both a private cable provider and a municipally owned cable provider, if the municipal provider, you cannot advantage the municipal provider, all right-of-way has to be available on a neutral basis. All underhooking connections to city-owned poles have to be on a neutral provision. But more importantly, if the private provider is required to pay a franchise fee, the municipal provider must pay a franchise fee to make the competition equal. If this statute didn't exist, there would be no way to impose the franchise fee on the municipally owned utility. So where a municipal utility has a competitor and the competitor pays a franchise fee, the city has to pay the franchise fee. Now you'll notice in about the 5th line down there, there are 2 words. I've been concentrating on franchise. Run back a little bit, you'll see the word ordinance. Well, there is another statute which may come into play, because cable communications utility may not have a franchise if it is governed under Chapter 480A, and it is required to pay fees under 480A. As a matter of fact, if you look at the end of 480A, you'll see that if you have a franchise, if charged under 480A, you cannot charge a franchise fee. This chapter applies only to cable. It does not apply to telephone, even if it's wire telephone, and it only requires that the payments made by one be the same as the payments of the other. There's a parallel statute which may seem a little curious to you, and this is 364.310. Under this statute, we're talking not about cable, we're talking about gas and electric, which is kind of odd, because what we're really talking about is when we have a public and a private provider of gas and electricity inside of a city. I am unaware, and I'm sure someone will educate me if they exist, I'm unaware of any place we have both a private and a public gas system. We do have cities, oddly enough, that have both a public and a private electric system, but not in the same place. What happens is that you have assigned service territories. These assigned service territories were assigned in the late 70s. Some cities have grown past the boundaries of their own municipal utilities, their own municipal electric utilities, into the exclusive service territories of cooperatives or exclusive service territories of investor-owned utilities. If the city franchises the cooperative or the investor-owned and charges a franchise fee, then the city has to charge a franchise fee to its own electric utility. There are several cities who have this situation. I don't know of any that are actually charging the franchise fee. A couple people on the line who may know if there's some who are doing it. But it goes beyond that. You have to have the same regulation of both utilities if you do this, and you have to be able to make sure that you are not discriminating in favor of your own utility. Okay, here we have another one of those statutes that looks kind of fun until you play with it. And we're going to play with it for the couple of slides here. Remember I said back a few slides that the city utility has to make money, has to be cost recovery based. Well, that is over time, and sometimes very little time, going to generate a surplus. And that surplus can be transferred. It can run out from the city utility. It requires some few things. There has to be a finding by the governing body, that's where we start, which is either the city council or the utility board, that there is surplus on hand, that's the second line, that you've complied, go down further, with all of the requirements and terms of any debt you have. Then you may transfer such funds to any other fund in accordance with the rules of the City Finance Committee, which is a state administrative agency, if the transfer is approved by the City Council. Now, that's kind of interesting. The City Council, of course, would approve it if the City Council is the governing body. If the Utility Board is the governing body, then the Utility Board has to get the City Council's permission to give the City Council money, which generally they're quite willing to do, but it is a procedural step that must be handled. Simply having money in reserve is not the same thing as a surplus. The utility could be building up a reserve to build a new water tower, to acquire additional electric generation, transmission. None of that's a surplus. Let's go to this phase, because this is the rule of the City Finance Committee. And it is the rule which the statute says a utility must comply with in order to transfer surplus from its funds to the city. Now, there's a curious thing in the middle. That is, you can transfer money to anything except the emergency fund. The emergency fund is a fund established by state law that allows the city to charge 20-some additional cents of taxes, but the only thing a city can do with the emergency fund is transfer money to the general fund. So the prohibition here is kind of odd. What it's really doing is prohibiting you from transferring money to a fund in which you can only transfer money to the general fund. So apparently you transfer the money to the general fund. Note the definition of surplus that has to accord with GAAP, and it must be such that the utility has at least an amount of money equal to 3 months of its previous expenses. So it does require that to have a surplus, you still keep a pile of money on hand with the utility, and then of course it requires, same thing the statute does, that you be able to have money on hand to pay all your debts and other obligations. Those aren't the only special rules. The statute sets some other rules in regard to the accounting of municipal utilities. The first one here is 388.5. The funds of municipal utility must be held in a separate utility account. That's true whether we're dealing with a municipal utility run by the board, a municipal utility run by the city council. If it's run by the board, no money can be distributed unless it's on the direction of the utility board, which is why on utility board agendas you always see that long list of bills to be paid, salaries to be paid, because nobody can pay money except on direction of the utilities board. Next section has to do with the again with accounting, and again it sets that the money not only has to be in a separate account. If you've got a utility board, it has to be with the treasurer of the governing body and kept in a separate account by the treasurer. There is an exemption right there at the end. If the city council is the governing body, it can use somebody else as the treasurer. Now, there are an additional set of rules that apply only to telecommunications utilities, which includes, under this section, this is the end of 388, it's the last section of 388. Under this section, that includes cable, phone, internet, and is here to try and keep the specific portions of the utility that provide communication services separate from everything else. And there's a laundry list here of things that you cannot do. You cannot provide any other city service which costs less if it were paid. You cannot favor your own utility by using other utility services or other city services to subsidize either directly or indirectly is the quick way to think about this. The providing of communication services. Here's the list at the top of this page of what's included, and it really is long distance telephone and local telephone for these purposes are separated for all practical purposes, are the same thing. They're not separately treated anyplace else in the code. Here is the important part. If the city can't transfer funds to a telephone utility, communications utility, how do you ever start one? How do you ever make the investment to start one? This section, subsection 2 of 388.10, is where you have to go. First of all, you have to go down a ways. You will see this is the key language toward the bottom. This section shall not prohibit a municipal utility from utilizing capital from any lawful source, provided that the reasonable cost of such capital is accounted for as a cost of providing service, which means any place you can borrow the money, including other utilities, is a lawful source. You can get it there. Then you have to go back up. You have to have records show the amount the amount and source of the capital for the initial construction or acquisition. And then at the bottom, you have to make an allocation of the costs of the system. And that comes from the fact that if you go to most small towns, actually, who have multiple utilities, you'll see a utility building. And in many cases, they'll be running all 4 utilities out. Well, if you're supposed to separately account for each utility, and especially there's a strong separate accounting for the communications utility, it requires that you make an actual allocation. Now, I told you there was an exception, and here it is at the top of B for promotional rates, and it doesn't look like that until you realize that you go back and see what telephone utilities can do, and this applies then to telephones. However, this paragraph shall not prohibit a municipal utility from establishing market-based prices for competitive telecommunication services. So you can do a promotional rate. It can't undermine you in the long run, though, because you're still governed by 384.84, which means your total cost of recovery has to cover the cost of the utility. There are a couple of things here on this page. Look at 7D. The utility is required, it's a communications utility, to annually annually certify its compliance with this "we aren't subsidizing" provision, and the accountant has to make such a certification. It is common, and I think you probably, for those of you who represent municipal utilities, look at the end of the last audit you received. It is still common for auditors to miss this requirement, and they need to start picking it up because it's in the code, and they're the ones who are responsible for attesting that the city is in fact complying with the non-subsidy portions for communications utilities. Lastly is a very long section saying you can put all your utilities on one bill as long as you show separately what each utility is, and you can show the amount that somebody owes. So that's not considered part of the subsidies. There are some exceptions you should know about to public records and public meetings law, which apply only to municipally owned utilities. If you look at the end here, this is customer records. They're outside of 22. You don't have to reveal them. But note the parallel with Chapter 476 is the Iowa Utilities Board. Note the parallel to the Utilities Board. You've got to be compliant with both. This is a section that applies. If you read it, it looks like it applies to all municipal utilities. It applies to telecommunication and cable utilities. Those are the only ones that are competitive. Those are the only ones that can take advantage of this section, which allows you to keep certain records closed and certain meetings closed. Now, look at what it says, though. It's not just because you're doing something competitive. The discussion has to be, for a closed session, has to be about marketing, pricing strategies, or proprietary information. Proprietary information is defined, and that'll be the next slide. That's all you can keep, and but you have to make another finding. You have to make it disclosure would be no public purpose and would put you at a competitive disadvantage. The same thing down below has to do with the records. So the records and the meeting are both covered by the same statute for competitive purposes. They have to, again, be pricing, marketing, preliminary worst papers, spreadsheets, those things that have to do with the competitive position of the utility. Note the in language under Section 2 in regard to the records. When public disclosure would no longer harm the competitive position, they become public records. So they're not outside of the statute forever. Once you no longer have them for competitive purposes, they're public records and should be disclosed. Here is the proprietary information definition. Again, it's a very limited definition, and it's what you can keep, part of what you can keep private, very important. I want to get to this. I've got a few minutes left, and I want to leave a little time for questions. It has to do with taxability. Generally, when you would say, well, it's publicly owned, it's not taxable, and the answer to that question is no, that's not true. There are actually three things in this section that make a utility taxable. Two of them are direct and one of them a little indirect. The first one is that to be tax exempt, municipally owned property must be two things. It must be publicly owned, and it must be devoted to public use and not held for pecuniary profit. Now you see I cited a case down there, City of Muscatine versus Swickard. Again, a recent case for those of us who practice municipal law, a really recent case because it's actually in Northwest 2nd. Swickard said that the electric distribution system of the City of Muscatine, located outside the boundaries of the City of Muscatine, were not devoted to public use. They were devoted to private use because they were solely being used by the city to generate revenue that may have aided the utility, but it wasn't the purpose of the utility, ergo taxable, which is why, if you are ever curious, you get a tax bill for the portions of a utility held outside of a city that's Swickard. Now, you've got to read Swickard carefully because it isn't as broad as I just stated it. Those things like the well field, the generation plant, the sewage treatment plant, those are all for the benefit of the people in the city. Those are not taxable. Now, the next taxable sentence has to do with jointly held municipal electric property that's financed under Chapter 28F. That's taxable. Those are the big generating plants in which the cities own a portion. And lastly is I'll just read this and then tell you all the fun it is. Facilities of municipal utility that are used for the provision of local exchange service pursuant to Chapter 476, but only to the extent such facilities are used to provide such service. That's a telephone. You go through it. They didn't say telephone. That's what it is. A municipally owned telephone is taxable. Trouble is there are no municipally owned telephone systems. The city-owned communication systems, modern communication systems, what all the cities in Iowa who have telephone systems have put in, the telephone is a small portion of the communication system. The question is we have no idea what portion. The Department of Revenue has for years said they were going to promulgate rules. They have not promulgated rules. If you have a municipal telephone utility or contemplating one, what you know is you will simply negotiate with the Department of Revenue what percentage of your system is actually devoted to telephone, which will include percentages which you will maintain are not devoted to telephone and aren't, but they're available to telephone. That's all taxable. This is another taxation which some people miss, and what this is the general taxation. General sales tax isn't applicable to municipal operations. Flip down, except it is general. The general sales tax is applicable to municipally held gas, electric, heat, television. Basically, municipal utilities pay sales taxes. The rest of the city does not. Okay, the Utilities Board. The Iowa Utilities Board, the regulatory agency of the state which controls and regulates utilities, has some limited authority over municipals. First of all, they don't have general authority. 476.1 sub 4, which you have there in front of you, has down there in the sort of the middle that municipally owned utilities are not subject to regulation under this chapter. And then this is going on. This is sub 5. This chapter does not apply to, second line, municipally owned waterworks. And then you get to 476.18 and you discover, by golly, there are things the Utilities Board does control for cities. Let me highlight the ones that are both controversial and important. Important. B, I've already mentioned this once, safety standards. The Utilities Board controls every utility, whether it's publicly owned, privately owned, cooperative, every utility safety standards. Everyone must comply with the Utility Board safety standards. That's the entire sentence. It's not even worth fighting about. Next, you have the assigned service area. That applies to electric utilities. City-owned electric utilities have an assigned service area. They're under the exact same rules as everybody else. They're required to provide service in those areas. We'll get to that statute itself in a minute. It has some exceptions which are worth noting. Disconnection of service, that's E. The thing with disconnection of service is we don't know what it is, and we're probably going to get in a war with the Utilities Board one of these days over what disconnection is. Notice on the next page that the alternative energy stuff does apply to municipal utilities. And lastly on that page, number 3, if you have a municipally owned utility that provides phone service, the Utilities Board's regulations do not apply to it. I'm going to fly to the end of this one. This is the section on utility assigned service territory. It flew too far to the end. It's not moving. There we go. Here we go. These are the reserved municipal rights under 4, and they are when you get into some discussions with the Utility Board, noting that you have some reserved rights is a good thing. There they are. We'll be very quick about this, and I'll actually be leaving 5 minutes. This is the telephone service provision. You cannot provide telephone service in Iowa if you don't have a certificate of necessity from the Iowa Utilities Board. That's section 2. And it sets all the things you have to prove, and it proves that you have to have the financial capacity, managerial ability, blah, blah, blah. And then you get to 13, and you discover that if a municipal utility has had an election and has been approved by the election to provide telephone service, miraculously, it is assumed to have the technical, financial, and managerial ability to actually handle the handling of telephone service. I've got 5 minutes left for questions, Christy.